Good morning and welcome to the IWC Orders, What Are They and How Do They Apply to My Business webinar. I am Denise Keddy, your moderator for this session. A couple quick housekeeping notes before we introduce our expert panel. The webinar will run approximately 60 minutes in total, and there will be time at the end of the webinar to address some of your questions. If you have questions during the presentation, please post them to the Q&A area that's listed on the dashboard. Take a moment now to visit the handouts area, also located on the dashboard, to download the 3 documents that have been posted. Linda Duffy will review these handouts during today's session, so it would be helpful if you download them now. If you have any issues during our presentation, please email me directly at denisemkeddy@gmail.com. Just a quick reminder that today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today provides general information and does not constitute legal advice. We recommend that you consult with your own legal counsel to address your specific situation and needs. The Industrial Welfare Commission, or IWC, has created orders to regulate wage, hours, and working conditions in California. To help us break down and understand IWC orders, I'd like to welcome our expert panel today. Our legal expert is Marla Merhab Robinson, partner and head of the transactional department at Merhab, Robinson, Jackson, and Clarkson. Marla's reputation among her clients and peers is that she delivers personalized service and that she is responsive, reliable, and extremely well respected. There are many law firms in Southern California, but what sets Marla and her entire team apart from other legal firms is that she and the members of her firm have all worked in the corporate world, so they really have an understanding of the business challenges and legal concerns your company is confronted with on a daily basis. Our second presenter today is Linda Duffy, president of Ethos Human Capital Solutions. Linda is known as the people problem solver. She develops strategies for business leaders to get the right people, systems, and culture in place in their organization so you as the business owner can focus on achieving your goals. She and her team are strategic advisors helping business owners with human resources consulting, recruiting, and training. And her clients range from high-tech businesses to manufacturing firms to nonprofit organizations. Linda also specializes in addressing the concerns of founder and CEO-led businesses. Ethos is happily celebrating their 10-year anniversary this year, so congratulations to Linda and her team. Thank you both for being here today. And Linda, can you get us started on this topic today?
I can, Denise. Thanks so much for the introduction. A few people have joined since Denise started, and so I see we already have one question about the handouts. So before I go through the agenda, I'm just going to say this a few times throughout, just make sure as we catch new people joining the webinar. If you look on the dashboard to the right, you should see a section that's titled Handouts, and you'll see it says Handouts 3 of 5. There's 3 different handouts there, including the slides from today. So it says IWC Orders PowerPoint and then slides handout. You'll also see IWC Article 5, which is the one we're going to break down today, and then another document called Which IWC Order Classifications. So all 3 of those have been uploaded. You should be able to see them over in your dashboard on the right. And feel free to download those. It'll help you as we go through today. So before I get started, I'm going to apologize. Both Marla and I have been sick, so we're going to try really hard not to cough in your ear as we talk today. Excuse me, I say that I start coughing, of course, but let's go ahead and get started. Thanks so much for joining us today. So here is our agenda we're going to talk about. You know, one of the reasons we wanted to do a webinar on the wage orders is because we encounter employers all the time who've never heard of them. They don't know how critical they are to California employers in the area of wage and hour laws. So we talk about the labor code a lot. A lot of times employers don't understand that there's a big difference between federal law and state law, and they don't know where the state law is actually spelled out. And this is one of the big areas where you need to go to research before you make changes in your organization. So a lot of this is in the labor code. There are some unique things depending on the industry that you're in or the type of job that you have. And there's a lot of exceptions and details we're not going to have time to cover today. So we just want to make sure to point that out and make sure we're going to talk about how to know which particular wage order is going to cover you. And so we just want to make sure that you take the time to research this and to read the fine print, so to speak. Okay, so what we're going to talk about, a little bit of history on the IWC itself, just talk about federal and state wage and hour laws. Already I've referenced them. Talk about the wage orders and which wage order applies, and then go through some of the exemptions and the exceptions, and just break it down and go through every single section for you real quickly, or most of them, and then answer any questions that you may have. So a little historical perspective, just at a really high level. The Industrial Welfare Commission was actually created a really long time ago, 1913, before Marla and I were even born. And was meant to regulate wages, hours, and working conditions in California. Congress didn't even enact the FLSA for another 25 years after this. So again, this is where California sort of led the way. The commission itself was, because it's no longer in effect, the commission itself was a group appointed by the governor. And so they took 2 people from organized labor, 2 representing employers, and 1 member from the public at large. They got appointed, and they served 4-year terms. Now, from the time to time over the years, the IWC amended the wage orders and added to them. So most notably in 1979, in the late 80s, and again around 2000. And then one of the most notable amendments, people that have been doing this for a long time might remember, was the removal of the daily overtime back in 1998. And then when that happened, then Governor Davis quickly responded by signing into law AB 60, which was called the 8-Hour Day Restoration and Workplace Flexibility Act of 1999, which went into effect January 1st of 2000. So there was a short period of time where all of a sudden California went back, if you remember, did not have the daily overtime requirement, and then right away was fixed. So the legislature ordered the IWC to implement these wage orders consistent with AB 60. So you'll see the wage orders actually sort of get dated, if you will. So it'll tell you which is the most current one. In July 2004, the legislature defunded the IWC entirely because it refused to increase the minimum wage. It also, under AB 60, when that was passed, it diminished their authority anyway, which had been previously tasked with establishing wages, hours, and working conditions. And since then, this legislature pretty much manages the development of the law, and then it gets codified in the labor code. So even though it's no longer the IWC Commission, or the IW Commission is no longer really in effect, the IWC orders still remain the place you need to go to figure out California law, in addition to the labor code. So you can read about the history of it if you're really a history geek. You can read about the history right there with that link. But today we're really going to focus on the wage orders and how they are actually as of today. So when we talk about wage and hour laws that apply to California employers, of course, we're subject to California and we're subject to federal law. And in some instances, it's going to be local law. For example, minimum wage is a perfect example, where there's different cities and counties throughout the state of California that have a higher minimum wage than what the federal government requires or California across the board requires. So you always have to look at all of these, but just at a high level, at the federal level, we have the Fair Labor Standards Act that oversees, that talks about the wage and hour laws, and that's enforced by the Wage and Hour Division of the Department of Labor. On California's side, we have the California Labor Code. We have these 18 wage orders. I think some of our material said 16, so a couple of astute HR people pointed that out to me. I usually say 16 only because there's one minimum wage order that we're not going to talk about today, and there's one of the 5 occupation orders that say miscellaneous, so it doesn't come into play very often. All of that is enforced by the Department of Labor Standards Enforcement at California. Now, also keep in mind that when a conflict exists between the federal and the state, such as minimum wage, the law that provides the stricter standard or the greater benefit to an employee generally prevails. So again, another example would be federal law only requires payment of overtime after 40 hours in a week, whereas California law has a daily overtime requirement. So whatever is going to give the greater benefit to the employee is what you need to go with. So here are some considerations in wage and hour law. And just a little disclaimer to remind everybody is we're not discussing union contracts or government employers because all bets are off with them. If you're subject to a collective bargaining agreement, that's going to prevail. And same thing with government employers. This may not apply because usually government is the first thing they do is they exempt themselves. We've had another 10 people or so just jump on the line, so I just want to point out that we do have 3 handouts for you in the dashboard that normally, at least on my computer, shows up on the right. If you scroll down, you'll see a handout section where you can download the slides and then a couple of other handouts we're going to talk about. Okay, so when we're determining which wage and hour laws apply, you need to take a look at all of these things on here. So for example, FLSA coverage, whether an employee or the employer is covered by the FLSA at the federal level, because there are some small distinctions. Almost every employer is, some small distinctions. Second, the labor code and the wage order coverage, whether the employer is covered by California industrial or occupational wage orders, in addition to the provisions of the California labor code. And we're going to talk about how to know which wage order in a second. Some industries have specialized regulations. So for example, if an employer is engaged in a business subject to special federal wage and hour regulations like railroad industry or merchant marines or something like that, civil aeronautics, there might be some other additional specialty things. Department of Transportation, for example, would have additional requirements. If you have government contracts and relationships, you might have additional things there. If you have, if you work on a public works contract or something like that, where you might have, for example, like a prevailing wage requirement, certified payroll requirement. The relationship with the worker has to be taken into consideration to make sure that the worker actually is an employee. So for example, a lot of these laws won't cover volunteers. They may not cover interns. They don't cover independent contractors. Now you have to make sure you have people classified correctly, but that's something to take a look at to see, do we even have to worry about all of these different laws for this particular individual? And then employer exemptions. Some employers may be subject to all of these wage, everything in the wage order, or might have partial exemptions. So like I mentioned before, state and local governments exempt themselves, for example. Hospitals, as another example, enjoy a partial exemption from some of the weekly overtime requirements. So that's another thing to consider. And then also employee exemptions, whether a particular employee or a group of employees may not be covered. And we'll reference that in a second when we're talking about, for example, executive, administrative, professional, the white collar exemptions or outside salespeople, where they may not be subject to a minimum wage or an overtime exemption. Okay, so let's talk about the wage orders. So again, if you look on the right-hand side under the handouts, you're going to see 3 handouts. And we're going to talk about IWC Article 5 today, Wage Order 5, but I wanted to point out that there's a handout here called Which IWC Order Classifications, which is a booklet that I'll talk a little bit more about, but that's a really good, helpful resource for you. So to determine which wage order you're subject to, the first thing you want to do is take a look at the industry-wide orders, and those are at the top on this slide. So when the IWC came out with these orders, the first one I think was back a long time ago was for the canning industry or preserve. So that can tell you how much agriculture was going on in the state of California. They've come out with all these other ones. So there are, the first 12 right here are actually occupation specific. So the first thing you need to do is say, okay, are we subject to one of these occupational wage orders? And if you are, that's the one that's going to control your particular employer. If for some reason you don't have, your industry is not listed or covered, and you have to look at the definitions to know this, if they're not covered, then the next thing you're going to do is you're going to say, okay, let's look at the occupational ones to see if there's an occupational one that covers what our employees do here. Now, the most common industry wage order is wage order number 5, which is the public housekeeping one, but when we get into the details, you'll see why that is. And then the most common occupational one is wage order 4, which is the professional, technical, clerical, mechanical, and similar occupations. So let's look at how to apply these. So we're not going to be able to take questions today about, have you ask us about your particular industry. You're free to reach out to me and Marla later if you need some guidance on this. You can engage one of us to help you with this analysis, but essentially here's how you sort of have to think through. So here are some examples. So IWC Order 1, which controls the manufacturing industry, would cover an office assistant employed in that manufacturer, if it builds automobiles, because the company is covered by an industry order. Okay, but let's say that same office assistant works for Marla and her law firm. There's no IWC order covering law firms. So that office assistant would be covered under IWC Order 4, because generally what would go on in that law firm would be that professional, clerical, mechanical designation. Okay, so it's the same position, but this is why it's so important you take a look at it, is because, okay, manufacturing does have a wage order, but a law firm does not. Okay. IWC Order 5 is another example that's the public housekeeping industry, would cover a nurse that works within a hospital because the hospital is covered by an industry order. But if that nurse worked in a doctor's office, they would be subject to Wage Order 4 because doctor's office does not have an industry order. Okay, so even though you think, oh, well, it's a nurse, it works in both, they do the same job, yes, but you look at the industry first, and then second, you look at the occupation. So the last example here is the mercantile industry applies to a bookkeeper like in a retail store, because retail stores are covered by Wage Order 7, but that same bookkeeper, if they're working in an accounting firm, or again, like in a law firm, there's no coverage under an occupational order for that. So they would be covered under IWC Order 4. So it can get a little confusing, and that's why we always suggest you take a look at this particular document. This is the same thing that Marla and I go to when we get asked by clients. So we'll go to this and we'll take a look and try to figure out, okay, which order, is there an industrial order that covers that industry, and if not, then we take a look at one of the other wage orders to see if it applies. Now, a lot of times I get asked, okay, well, can you have more than one wage order? And the answer is generally no. Now, it would happen if you had like a parent company that owns and operates subsidiaries, and each subsidiary may be governed by a different wage order. So let's say, for example, a parent company owned a company in the construction industry, and then they also owned a manufacturer, then the construction industry would be governed by one wage order and the manufacturer would be governed by a different one, right? So even though they have the same ownership at the parent level, the subsidiaries would have different one. But let's say you have a business like a private university, for example, they may provide board and lodge and lodging to its students in addition to educational programs. You may have teachers, you may have laundry workers, housekeepers, computer programmers, librarians, etc. But all of the employees under the university would be subject to Wage Order 5 because the definition of Wage Order 5 reads any industry, business, or establishment which provides meals, housing, or maintenance services, whether operated as a primary business or when incidental to other operations and establishments. And then it goes on to say it includes, but it's not limited to, restaurants, catering, hotels, hospitals, private schools, and like veterinary care services. So this is what you need to take a look at. The other thing, another couple things just to know is that temporary employees, I've got friends that own temporary agencies and I don't know how they even deal with this sometimes, that temp employees are subject to whatever wage order governs the place where they're working. So even though the temp agency itself may be subject to Wage Order 4, if you send somebody out to work in a manufacturing operation, for example, then you have to play by those manufacturing rules. If temporary employee could be sent out to multiple establishments in the same work week, and what the IWC has determined, or I guess probably the courts, because it's probably been litigated, if an employee is assigned to more than one employer in a pay period, then the standards will be determined by the wage order under which the employee worked the greatest number of hours in that pay period. So if somebody goes out and works, 2 days in one place and 3 days in another for that whole week, you have to play by the rules under that, the 3-day, industry or occupational order. Again, I don't know how anybody does that. I also don't know how, that would have to be a pretty serious audit to probably ever get caught on that. But that was something just for if you're owning a temporary agency, you need to be careful about. So again, that IWC order classification, you can't tell it's really a picture there, but the thing on the right, that's literally what the cover looks like. So which IWC order, and you can download it from the handouts on the dashboard. Okay, when you look at the wage and orders, all the different wage orders, there's a whole bunch of different sections. There's 20-something sections, and we're going to fly through these today. But there are a lot of similarities, right? So a lot of these that are listed here are identical. The problem is there are some very different sections when it comes to, who it covers, obviously, and overtime pay rules, and then also those exemptions. And that's why you have to really read the fine print. So there are some common full exemptions under the wage orders. I already mentioned, like volunteers and independent contractors, obviously not covered because they're not employees. Government employers other than minimum wage rules are exempt on pretty much all of these. Family members. So a lot of times I get a phone call, well, can I not pay my daughter to work at the company or something like that? Can she, quote unquote, sort of volunteer? And this is where you find the answer is there's a specific exemption in these to say anyone who's the parent, spouse, child, or legally adopted child of the employer is exempt from the wage orders. So if you have a cousin working for you, you still have to play by those rules. But if it's one of those people listed there, you don't have to pay the minimum wage or pay them overtime. The white collar exemptions that we've done many webinars on in the past, if they're executive, professional, or administrative exemption, they're not subject to some parts of this. And then also outside sales people are completely exempt from the minimum wage and overtime. So a couple things to keep in mind though, because we get these calls a lot too. Employer size does not matter here. There's no minimum. You have one employee, you're subject to the wage order. It also does not matter if you're a nonprofit or a nonprofit that has a religious organization status. It does not matter. So a lot of times nonprofits think, oh, we're exempt. We don't have to play by overtime. I don't have to pay them overtime, or I don't have to pay them minimum wage. That's not the case at all. So you want to make sure it doesn't matter the size of your employer, does not matter if you're a nonprofit or a for-profit organization, you're still subject to these wage orders. Okay, partial exemptions. So this is, again, we can't list all of these partial exemptions, but what this means is certain employers may be covered by some of the provisions in that wage order, but not other parts, or some employees may be covered by the wage order, and may be exempt from other parts. So you have to read the wage order really carefully to understand if there's a partial or full exemption. So if you look at these examples here, drivers are regulated by the Department of Transportation, so they aren't subject to the overtime rules, but they are subject to meal and rest period rules. Taxi cab drivers are exempt from the overtime rules in Wage Order 9, and then ambulance drivers and attendants have partial exemption depending on which wage order they fall under. Commission employees, I'm going to mention this on another slide, under Wage Order 4 and 7, there's some specific rules about whether inside sales reps can be exempt or not from overtime. And just in case you were ever wondering, I was fascinated by this, ride operators at traveling carnivals are exempt from overtime and minimum wage provisions. And actors and actresses are completely exempt from wage orders 11 and 12 that cover those industries. Okay, so a little just nerdy detail there for you. So let's break down one of the wage orders so you can see what it contains. We selected Wage Order 5. Again, you can download this in the handout section because some of these I took screenshots. Some are going to be pretty hard to read probably on the slides. This is the most common industry order in California. Okay, so it says here that it's public housekeeping. You can see Wage Order number 5-2001, right? Public housekeeping industry. It was effective on the date where it was last amended. You also notice it says this order must be posted where employees can read it easily. So just keep that in mind as well, and we'll talk about that a little bit later. But the public housekeeping industry say, okay, but I don't have housekeepers. But the question is, so what is public housekeeping? And Section 2 of the wage orders have definitions in them. So here's a definition of public housekeeping. So you can see it's pretty extensive. It's not just like, oh, I have, a janitorial service or something like this. It means any industry, business, or establishment which provides meals, housing, maintenance services, whether operate as a primary business or when incidental to other operations. And it goes on, and look, so it's restaurants, it's catering companies, it's hotels, motels, hospitals, private schools and colleges, right? So there's a whole bunch of different industries that are covered, even though it's titled public housekeeping. So you always have to look at the definition to see veterinary, establishments, animal care is covered under the same thing. Okay, it's not what I would consider to be housekeeping by any stretch, but nevertheless, it's covered by this definition. And so you have to read the definitions. And again, it's all contained in that handout that's called Which IWC Order. So just take a look clearly at the definitions to make sure you know whether or not this one applies to you. Okay, so then you also want to take a look at the top of section 1 because it'll tell you the applicability of the wage order, and it also notes any exceptions. So again, a little bit hard to read on some of the screenshots, so open up that IWC Article 5 handout and you'll be able to see it for yourself in larger print. But for example, there's some exceptions here, and it goes through the exceptions right at the top in section 1. So this one doesn't apply to student nurses. Okay, doesn't apply to psychiatric technician examiners. I don't even know what that means, but I'm sure if I was in that industry and I had one, I would be, oh, okay, I know I don't have to, I know that there's going to be an exemption here for them. And then, of course, a lot of them, probably all of them, have administrative executive professional as an exemption, right? So you go through that. Now, there's that section. The section B, where it goes through all those exemptions, is a lot of great detail we're not going to go through today. And then you skip down to C, and it goes on to further say if you're employed by the state or a political subdivision thereof, so again, the government exempting themselves, you're exempt from this wage order. And if you're an outside salesperson, you're exempt. Here's where it says if you're the parent, spouse, child, right? And then if you're an individual participating in a national service program, you're going to be exempt as well. So that's why you want to take a look at the applicability of the order, because it's going to outline for you any of those exemptions that apply under this order. Again, definitions are important. So there's a whole bunch of definitions. The one I showed you before is from P, so that'll give you an idea. It goes through, but this is where it tells you things like, what do we mean by employee? What do we mean by hours worked? Who's an outside salesperson? So one of the questions we get asked a lot when people say, oh, I don't have to pay overtime to my outside salespeople. I said, well, let's make sure that you're complying with the definition of outside salesperson. So if you look at the bottom line here, it says they have to be 18 years of age or older, right? But who customarily and regularly works more than half the working time away from the employer's place of business, selling tangible or intangible items, and goes on from there. Okay, so you can't be an outside salesperson and be sitting in an office, whether it's the company's office or your home office. You have to be out, like face-to-face selling or getting contracts for products and services. So that's how we know like where the definition comes from and what constitutes an outside salesperson, because they spell it out right here in the definitions for you. Section 3 is the hours and days of work. So this is really the big one, right? Section 3 is super long, and it's really the most important one for most of my clients. Most of the calls I get are about this. So this is really important because it talks about days and hours of work, obviously, and you have to read the fine print because, again, there's going to be different rules for when you have to pay overtime under which type of circumstances. So when we say in California we have a daily overtime provision, this is where you can find it. So if you look at, subsection minor A here, 1.5 times the employee's regular rate of pay for all hours worked in excess of 8 hours in a day, right? So it goes on from there. So you also, a lot of people don't realize you have to pay overtime for the first 8 hours worked on the 7th consecutive day, right? And then double time for anything over 8 hours on the 7th consecutive day in a work week, okay? So this is where everything here is outlined, okay? All right, the other thing that's contained in section 3 in 3B is alternative work week schedules. So again, we could probably do an entire webinar just on alternative work weeks and how to implement them. Every single one is a little bit different. So you have to take a look at this one and say, okay, so if we're in public housekeeping, what are our options if we want to have people work more than 8 hours in a day and get around this whole overtime thing? What we're going to do is we're going to say, okay, do we have the ability to have an alternative work week? And in here, they say, yes, you can schedule people for not more than 10 hours in a day within a 40-hour work week. So people would refer to that as a 410 or a 440 work week. Okay, we're going to have people work 4 10-hour days, and that would be fine. And then we wouldn't have to pay them overtime for those extra 2 hours. Now, it goes on to tell you how you have to implement that and everything, but look further down here, there's another exception. So it says if you're in the healthcare industry, you can have them work not more than 12 hours a day. And then it goes on to say, provided that, right? And there's different sub rules there that you have to take a look at. So generally, if you're under this wage order, you can have people work 4 10-hour shifts and you're fine. But if you're in the healthcare industry, and again, there would be a definition for that, you can have people work not more than 12 hours in a day without paying them overtime. Okay, so that's what's important to know. Again, and why it's so important to read the details on each of these sections. Excuse me. So the alternative workweek elections in 3C, it goes through, there's several different things you have to do in order to put an alternative workweek in place. And again, we're not going to go through all of these rules. If you need help doing that, then you can engage Marla's firm or my firm, and we'll come in and help you do that and put that into place. But a lot of times we'll encounter an employer that's have people working some funky shift. Oh, everybody works an extra hour each day, but then we let them go at noon on Fridays or something. I said, okay, did you put an alternative work week in? No, what's that? Okay, so it's really important that you follow these rules, because if you don't have it done correctly, you could have potentially 4 years of back overtime pay and penalties on top of that. So you want to try to avoid that. If you don't know whether your company has put it in place or not, there actually is a database with the state of California, so it's easy to find out. Go to this link, put in the company's name or whatever information you have, and then it'll print out for you and it'll tell you. So this is actually one of my clients where we put this in a number of years ago. So it tells you everything about it. It tells you the name of the company and where they're located, the date of election, when we sent the letter in, right? The date it was received, which I don't know why that's 2.5 months later, but anyway, what the vote was, right? So 9 out of 11 affected employees voted in favor of it, and they adopted a 4-10 work week. Okay, and then other description and everything else that goes on from there. Okay, so that's a great place to just take a look. If you don't know whether you have one or not, double check it. And if you don't have it, then call Marla's office or my office and we can help you put it in. Okay, I mentioned this before. There's some partial exemptions and full exemptions. One of the ones that we see a mistake on a lot has to do with inside salespeople. So wage orders 4 and 7 only have an exemption for inside salespeople. They may be exempt from the overtime overtime rules if they meet specific criteria and they fall into those 2 wage orders. Okay, so the section says the provisions of those subsections, right, shall not apply to employee whose earnings exceed 1 1/2 times the minimum wage if more than half of the employee's compensation represents commissions. Now, I will say this has in addition to this, there is litigation, right? There's case law on this. There was a case that came out in 2014 called Peabody versus Time Warner Cable on this very topic. It did clarify how commissions need to be applied. So it's not so simple as now just looking back and saying, well, do they make more than half in the form of commission? It depends on how you're applying that and how often you're paying it. So again, if you have inside sales reps and you want to make them exempt, be very, very careful about that and make sure you reach out to one of us to help you with that. Okay, but the reason I point this out is, let's say you have a manufacturing company that's subject to wage order 1 and you have inside salespeople. You do not have the ability to make them exempt even if you met this criteria, because this is not an exemption for wage order 1. It's only an exemption for wage order 4 and wage order 7. Okay. All right, minimum wages. So again, this gets updated, as you can see. So even though the IWC, the Industrial Welfare Commission, has been defunded, since 2004, this is getting updated by the DLSE, I suppose, as minimum wage gets increased. You also notice that in this section, there's a couple other things, like you have the ability, if you have an employee who's considered a learner, and again, read the definition, that you can pay them less than minimum wage. It also talks about if an employee works a split shift, how that affects how you pay them, and if there is the sort of penalty for doing that if they have a split shift. There's also reporting time pay. So this is when somebody's required to report to work and then there's not enough work for them for some reason, right? But if there's not, this is how you have to pay them, and it spells that out for you. Okay, I think, Marla, did I skip over? I think I'm into your section here.
You are, and I can't believe it with that terrible cough and cold that you've taken on the bulk of this. We're almost done, and thank you for that. You want me to take over now?
I do. I'm sorry. Okay. I think I missed my slide marker that said I was supposed to turn it over to you. So let me turn it over to Marla.
Well, you're doing such a great job, and I didn't want to interrupt you, but I just want to remind everybody as I go into the next couple slides that what we're talking about here is obviously the wage orders, what they are, which Linda's done a great job of explaining how do they apply to your business. Every single one of you has either an industry or an occupational order that applies to you if you are an employer in California. And it's critical, as Linda said, to determine which one. And as she said, we're talking right now just about wage order 5. This may not be yours, but most of them are very similar in these sections that we're going to go on to now. But it doesn't mean necessarily that it does apply to you. So these are just examples, again, from Wage Order 5. And the reason why Wage Order 5 is the most common is because of the language in the definition. And that's why, as Linda pointed out, the definition sections are so important. Because it says in the definition that this is an industry, business, or establishment which provides meals, housing, or maintenance services, whether operated as, and here's the critical part, a primary business, which would be easy to determine. Okay, I have a hotel, I know I'm providing, I have a restaurant, I know I'm providing meals, or when incidental to other operations. So you could have a business that manages a hotel, but also happens to own a hotel, and then this order would apply. So it's just such a broad definition that you could slide in as she explained universities do. So the next section in the Wage Order 5 is the reporting time pay section, and as you saw from Linda's slides, this is all about wage and hour, and then a couple other things thrown in. But this is, another wage. It's reporting time pay. The section sets forth when the reporting time pay is required, and it's an employee reports to work on a scheduled workday, but is not put to work or is furnished with less than half of his work. So there's 2 times when reporting time pay is required, and the employee must be paid the greater of half the usual scheduled day's work, up to 4 hours max, or 2 hours of regular pay. If the employee reports to work a second time in a scheduled workday and is furnished less than 2 hours of work, he must be paid for 2 hours at his regular rate. So that's set forth in A and B. And then C tells you when it's not applicable. And this is typical examples if it's not the employer's fault. So for example, if there's a work strike, that's not going to be the employer's fault. If there's public utility failure, any act of God, earthquake, that type of thing. The next section in the wage order is section 6, and this is licenses for disabled workers. Linda can chime in here if this has happened with her. I've not had this experience, but certainly, companies like Goodwill, who employ disabled workers for less than minimum wage for their operations, this is a section that applies to them. As Linda pointed out, with most, if not all of the wage and hour, I should say with all the wage and hour, you must also comply with FLSA unless you have some exemption there. So you need to look at federal law because, for example, here, licenses that can be issued by the Division of Labor Standards and Enforcement to allow for less than a minimum wage for disabled workers, this particular provision allows it here. The federal law also requires you to get a license there. So almost every instance we cover, you're going to need to look at federal law as well. The next section, section 7, is on record retention. And this is kind of broken up into 2 sections as well. There's the A section, which is what's required to be kept in your records. And there's a list, the name, the home address, occupation, et cetera. You can all read it. And then B is what's required to be given to the employee. And lastly, C will tell you what form it's got to be. This is a little bit different than a lot of other things. In ink or other indelible form, and properly dated with the month, day, and year, and for at least 3 years. Now, of course, your accountants and your attorneys may tell you to keep things for longer than that. We certainly do for statute of limitations purposes and for tax purposes. But this is a requirement under this wage order for these records is just 3 years. Also, remember that Labor Code Section 353 also requires records of tips and gratuities, whether received directly or indirectly, and that's not in this section. So again, you've got the wage order to comply with, you've got federal law to comply with, and other laws, including the Labor Code section, just to make it difficult for everybody. So the next section in the wage order is Section 8, and it discusses what's required for cash shortage and breakage to apply to a wage, to deduct from an employee. This is an area where employers make mistakes all the time, and this is an area of very high risk. And at the very end, I'm going to define what that risk is. But this to deduct from an employee's wage, you must be able to show that it was caused by a dishonest or willful act or by the gross negligence of the employee. So if the employee is just silly, if the employee is just stupid, makes a stupid decision, it's just negligence, not gross negligence, then you cannot deduct from their wage for any broken inventory, lost inventory, register cash shortages, any of those. And if you do so, and you can't prove that it was dishonest, which I would say intentionally stole from you, and sometimes that's hard to prove too. I had a case where the employee took a piece of inventory home, and when questioned about it, he said that his supervisor gave him permission to. Well, when we discovered it, the supervisor was no longer employed, so we couldn't determine whether, in fact, it was intentional or if it was something that was the supervisor's fault. The employee claimed that the inventory was already damaged. So if you do deduct and you deduct improperly, it raises all sorts of issues with respect to penalties if you haven't paid minimum wage or if you have not paid overtime correctly. And we'll talk about this when we get to the penalties. So the next section in the wage order is Section 9, and this is uniforms and equipment. And again, this is another section you need to use extreme caution. You need to have state compliance and federal compliance. You need to look at whether you have, as an employer, are required to pay for the cost of the uniform, and also whether or not you're required to maintain the uniform. Now, this section is misleading in some respects because it says it does not apply to protective equipment and safety devices on tools regulated by OSHA. And that's correct. This section doesn't apply, but OSHA has its own rules, and we have case law as well with respect to uniforms and equipment. The tooling provision of this section is often not correctly put in place by employers, because a lot of employers require their employees to bring their own tools. But to do so, you have to meet the requirements of this section, one of which is to pay at least 2 times the minimum wage. So you have to read these sections very carefully, again, for your applicable order, which may not be Wage Order 5. Meal periods. So the next 2 slides are meal periods and rest periods, and these are 2 areas that Linda and I have already put on a full webinar on. You can find it on our YouTube or on our websites. We could spend a full day seminar on either one of these. So I'm not going to go over the law there, but again, just as your starting point, your wage order is where you look first, your applicable wage order, and then you need to look at federal law and labor code and anything else that might apply. Again, just a reminder, this is just Wage Order 5. The next section in Wage Order 5 is Section 13, and that's change rooms and resting facilities. This is your employer's requirement with respect to employees who have to change during the working hours or have to have a place to put their coats if they were bringing in coats. And then also Section 14, which is seats. You've got to provide suitable seats when the nature of the work allows it, and that's not always. This is a fairly newer section. Now, I skipped a few sections. There are a few more after these regarding temperature, elevators, some more exemptions. So be sure to read the whole thing. The point here is in total the risk associated of making a mistake in any of these areas, which generally are mistakes tied to wages. And that risk is spelled out on the next slide, which is section 20, the penalties. So the penalties listed here are for violations of to the employees for pay. They were underpaid. There's an initial violation of $500 for each underpaid employee, and the subsequent violations $100 for each underpaid employee. And then, of course, anything they didn't get paid, you have to pay the wages that they should have received. Now, this is only part of it. This is bad, but it gets worse because, to Linda's point on the slide titled Considerations to Look At, it's more than just the wage orders. So we have also, many of you are familiar with Labor Code Section 203, which is waiting time penalties. So if an employee wasn't paid a wage or was improperly had their wage deducted, they didn't get their wage, they have a waiting time penalty that they're entitled to of up to 30 days. 1 day for every day they didn't get it, up to 30 days. We also have liquidated damages penalties found in Labor Code 1194.2 for those of you who like to look at the code sections. And for that, they call it a liquidated damages provision, but what it really is if you fail to pay the minimum wage, whether it be because you just didn't pay the minimum wage or you improperly deducted or you improperly calculated commissions, another good point by Linda, that case, the effect is it doubles the amount due. Whatever that amount happens to be, the liquidated damages provision under that Labor Code section automatically doubles it. So it's a huge number, oftentimes takes the number beyond even the waiting day penalties, which are also a huge number. And then you can add to that attorney's fees and costs for the employee. And if you're successful in defending, the employer does not get those attorney's fees and costs, but the employee does. So you can see the penalties here. This, in my consideration, other than how to determine which wage order applies, this is the most important slide of the day. So look at the risk. The next slide is section 22 of Wage Order 5, which is the posting of the order. Linda already noted on the front of the order, and it's true on all of them, it says it must be posted. I'm often asked, how do we post this? It's 11 pages. You don't just post the front page. You actually have to post the 11 pages, and that's not the equivalent. The second thing I'm often asked is of the poster. Well, I already have my California required poster. Isn't all of this in there? No. Some of this is in there. For example, minimum wage is in that poster, but not all of this is in there. So what you have to do is you have to print all 11 pages, somehow clip it together, whether it's by staple or other clip, and then hang it next to the poster. We often do it with a little nail or thumbtack or something. But it does have to be posted and available to all the employees. Now, one of the other things that's on this slide is the other languages. It has to be posted in English, but if you know you have other languaged employees, you should post those as well. And it's available in Spanish and Chinese and certain other ones. You can also call the department the Division of Labor Standard Enforcement, Department of Industrial Relations, and ask any questions, and they will help you with that as well. And I think with that, we turn it over to questions and answers.
Marla, that's great. And I wanted to go back just to one slide to touch on something real quick because we aren't going to spend time on this, but I cut out two different things. On the rest periods, Wage Order 5 and Wage Order 1. And I just wanted to draw your attention to it, just to emphasize this one point that we want you to walk away with today, which is you've got to read the fine print for your particular wage order. Because if you look at this, the top section was taken from the wage order we've been talking about. The bottom section was taking that same section, but taken from Wage Order 1, which is for manufacturing. Well, if you notice, A and B are identical, but we're missing C, right, on this other one. So there's the, rest periods, there's an exception for rest periods under 5, right, for certain, if, it says here, require an employee to remain on the premises and blah, 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 if this is a 24-hour residential care facility, right, which clearly does not apply under the manufacturing wage order. So again, you have to take a look at each section because they're not all the same. I just wanted to point that out to everybody. And with that, we're going to turn over to Denise to head up our questions section.
Great. Thank you both. We appreciate you drilling down into the wage order for us to understand how important it is to pay attention to those things. If you have any questions right now, please post them in the Q&A section on the dashboard, and we'll do our best to answer your questions. If we don't get to your question, we'll be sure to follow up with you afterwards. And contact information in case you do want to engage Linda or Marla with detailed questions on specifics regarding your business is listed in the handout. So if you didn't download it yet, I know we've mentioned it a few times, make sure you download it. You still have the opportunity to do so. Let's see, first question that we have. What if employers work out of the home? I've been in companies that have employees work out of the home. So how can a company comply with the IWC posting requirements that you just went over?
Great question. I'll take that one. So as Marla mentioned, you have a requirement to post this, but I mean, let's be realistic about it, right? So I'm not going to buy the poster from, like we usually recommend, Cal Chamber, get the IWC order, send it to my employees who work out of their homes and say, hey, post this in a nice conspicuous place where you'll see it every single day, right? So the only wage order that contains a specific exemption is wage order 15, which regulates household occupations. If you have employees that work in a private residence, then you're allowed to put it in a drawer, or something like that. You don't have to put it in the kitchen, where your nanny or cook works. But I think what it is acceptable to do is, we just did this for a client recently, is we downloaded all of the required posters individually and put them in a Dropbox folder, and then sent them to the client and said, send an email to your employee, have them respond, right, to acknowledge receipt, and make sure that they know where to go to get them. So you could put it in a folder on, like a shared drive, you could put it in Dropbox, you could do something like that. The point is to make sure that they know where it is and they have access to it. But I don't think you're going to be in a lot of trouble, nor do I expect that, DLSE is going to come knocking on my employee's front door and say, I want to inspect your premises, to see if the poster is there. So I wouldn't lose a lot of sleep over that one, but you want to make sure that you have proof that you've given them access to the posters.
All right, great. Speaking of the posters, I know, Marla, you just spoke about the posters, and we have a question here that said, you mentioned that there are different languages. So are we required to post in other languages, or is it an option? Is that an option determined by the prevalence of what employees represent those languages within the company?
The wage order is silent about whether you're required to post in others, but I would suggest to you that the whole point of posting, the requirement that is placed on the employers, is to give employees notice. So if you know you have a majority Hispanic, Spanish-speaking workforce or Chinese-speaking, that you would post it in all three. You want to be able to prove that you gave notice to the employees.
Okay, great. I have a question from Amy. Linda, you did discuss alternative work weeks, and she mentions that she's heard about a 980 work week, but not sure how it works. And can you give us an explanation on how this works?
Yeah, real quickly, because probably the most common one would be like the 440, or how I call 440, but 410 hours. And then in hospitals, they'll work 3 12-hour shifts, things like that. There's another great one that I know is under IWC Order 4. I don't know how many of them would actually authorize this, but anything that says you can work up to 10 hours a day without incurring overtime, then you would be able to do a 980. So the way the 980 works is you essentially have people work 4 9-hour days and then a half day. But what the trick is to it is, in week 1, you would have to redefine your work week. So in week 1, you would work like Monday, Tuesday, Wednesday, Thursday, 9-hour days, and then you would work 8 hours on Friday, but you would say, we now define our work week to start at noon on Friday. So in the first week, you'd work 4 9-hour days and say 8 to 12. And then the second week, you're essentially starting at 12:01 p.m. on that Friday, working 4 hours. And then the following week, Monday, Tuesday, Wednesday, Thursday, 9 hours, and have Friday off. So I've used this before when I used to work in-house. We've used it with clients where essentially over a 2-week period, you're working 9-hour days, but and then one Friday is 8 hours, the next Friday you get off. So the employees get an extra 26 days off a year. So we've seen that it cuts down on, other types of absences because they can schedule doctor's appointments. They get 26 3-day weekends, during the year. So you just have to, again, put it in correctly. And that one's a little confusing, especially if you need to split your workforce to have coverage on every Friday, but it can be done. So we can certainly help with that.
And that would be where you mentioned earlier about if a company chooses an alternative work week, you have to go in and file for that. Is that what you mentioned earlier?
Absolutely. So there's actually several steps, including you have to give people notice, you have to hold a meeting, you have to come up with some FAQs about how it's going to affect their benefits and their compensation, give them all that, give them a certain period of time to review it. Then you have to have an election, like a special election for those people who are affected. Then you have to file it with the state. So there's several steps you have to do. It's not hard, but you have to do it correctly.
Okay, great. If my company is based in California, do IWC orders apply to employees who are working for my company but live in another state? Marla, do you know?
Yeah, no, you have to apply the state where the employee is located. And federal law, of course.
And federal law. Okay, great. Another quick question before, if an employer has non-exempt employees and they have a semi-monthly pay schedule, what if the employee works under 80 hours in a pay period? Can I modify the pay?
I'm sorry, can you read it again? Is it a non-exempt employee? Is that what you said?
Yes. Yeah, so there's a non-exempt salary employee that's working, and if they get paid semi-monthly, and if the employee works under the 80 hours in that pay period, can I modify the employee's pay?
Okay, well, maybe Marla has a different answer, but I'm going to say a couple things. First of all, if you're on a semi-monthly pay period, then I think it's 86.67 hours per pay period. It's not 80, so I'm not really sure I understand that. It would be 80 if you were biweekly. If you're salaried non-exempt, I would say get rid of that classification because you're not doing anybody, yourself or the employee, any favors on that one. So those are my first two caveats. But if the person's non-exempt, then yeah, you don't have to pay them anything. If they're salaried non-exempt, that's a whole nother can of worms, depending on what you'd promised the employee that you were going to do and what your intent was with that salaried non-exempt. But if they're non-exempt, they only need to be paid for the hours they actually worked. Marla, do you want to jump in on that one?
No, I don't have anything to add. I agree. I didn't understand it at first, but I think you explained it. I mean, yeah, I'm not sure I didn't understand the question.
Yeah, I'm not sure. Well, and I may not be getting it either because I don't understand the 80 hours because if you're semi-monthly, it's more than 80 hours. If you're bi-weekly, it's 80 hours. But I'm not really sure I understand where the 80 hours is coming from on a semi-monthly because I think it's 86.67 hours.
Okay. Probably this will be the last question so that we can wrap up and get everybody out of here on time. If I've scheduled in advance, a staff meeting, do I have to pay to have people come to the staff meeting? So if I've scheduled a staff meeting, I don't know what kind of industry this is, so if I scheduled it in advance, do I have to pay when employees come to the staff meeting?
I think that was the reporting pay question. I think it was the reporting pay question, I'm guessing.
Yeah. Yeah.
Yes.
That's what it sounds like to me too. And you don't have to pay the reporting time pay if that's what's scheduled. And just to be clear, on the reporting time pay, or split shift thing, if it's the employee who causes the split, then there's no pay there either. But if the reporting time pay is when you change a regularly scheduled time. So if the employee's regularly scheduled to work 8 hours a day, as most employees are, or 410s, and they come and that's not, that regularly scheduled is not there, that's when that reporting time pay comes in. But if you've scheduled a meeting and it's only scheduled for 2 hours and that's all the employees coming in, that doesn't trigger the premium on the reporting time pay.
Okay, great. Great. Lynn, do you want to wrap us up with next
I
month's
do,
webinar
because
information?
I'm super excited about our webinar for next month. So we are very honored to have a guest speaker next month is Ron Williams. So Marla and I both know him, maybe Denise does too, I don't know, but he's going to be talking about workplace violence. So it's not a topic, of course, it's really cheery, but it's so important. And Ron is former Secret Service. He's sort of a badass. He is an expert in security and risk management. He does talks all the time. He has been on CNN numerous times. You know, when things happen out in the world that are unfortunate, people call him for his expertise. So he is going to be here on April 26th to talk about workplace violence, talk about you know, active shooter training, what companies can do. He's been working with the LA Unified School District, and he thinks that their model could be like a model for the nation. So I'm super excited to hear what he has to share with us. So bring your questions.
And Linda, can I interrupt here too?
Yeah.
I really want to strongly encourage, and I know this has been difficult for both of us being sick today, but I really want to strongly encourage everybody to come to the next webinar on this, because unfortunately we have just seen, just like you see in the news with the schools, we have seen such an increase in workplace violence. 30 years ago when I first started practicing law, it was, you know, somebody keyed my car in the parking lot, and now we're having poison in the coffee and guns and everything that you see in the public news. We're seeing that increase in the private employment sector. So please do try to join us. And if you don't get to join us, remember we do have it on YouTube and on the websites.
Awesome. All right, with that, I think that we are done. There's a registration link right there. So hopefully you can register for next month on April 26th. And on behalf of Denise and Marla, I want to say thanks to everybody for joining us today. And if you need help with any of this, just reach out to me or Marla, and we're happy to help. Thanks so much. Have a great week.